and we'll probably get a few more as we go. Lorianne, do you want to just tell us what you did with the, generally with this, and then we'll get into the nuts and bolts of it.
Yeah, so the biggest change from the prior version substantively is to try to incorporate some of the approach used by New York in the executive order allowing remote attestation. So we now are requiring that for a will that is electronically witnessed, you have to have the person signing the will has to present some sort of photo identification to the witness, like, showing them their ID, I guess, if they aren't known to the witness. They also have to, after they sign it, they need to then scan or somehow transmit the document to the person witnessing the document while still on the call with each other. And then the person witnessing the document needs to sign it, and they will then return the, they'll return an electronic copy of what they signed. So it'll have both signatures on at that point. And then the person who signed the document, so the executor of the will, let's say it's a will then transmit the actual physical copy or the physical signature page with the wet signature of the executor to the witness. So they'll FedEx it or mail it somehow, and then the witness will actually physically sign a wet signature to that same piece of paper and then return that to the person executing the document. It's a little convoluted.
Simple as that.
Yeah.
Right. First, let me just kind of well, I want to ask for general reactions to this first before we dive into it. But I also want to share that she's not on the call today, but I did have a lengthy conversation with Judge Burton last week about this, and I would say that Judge Burton was pleased with the, generally pleased with the redraft, except that she still does not support including wills as a document that can be attested remotely, and so was forthright and frank, but of course in a cordial and collegial sort of way to say that she would oppose this if wills are included. She thinks that between the harmless error rule and the probable adoption of the remote notarization statute, which she said she would not oppose, that she thinks wills are adequately covered. I'm looking, Judge Cobb or Judge, do we have any of our other judges on the call today yet?
This is Judge Cobb, and I also discussed it with Judge Burton, and she and I mean, I think from the last meeting, we were pretty clear about the 112.238 covers it, and the electronic notary covers it. And my understanding was that wills were out. I was kind of surprised to see it back in again, but.
Yeah, I think we hadn't made a final decision on that, but so folks, I think that sort of frames the conversation that I have about it today. As I said in our last meeting, I don't propose to use our considerable political capital to run over the judges in front of the judiciary committees. And so I think we have to consider that if this is going to go forward in any fashion, it's going to not include wills. And so we have that to consider, as well as the mechanics now that are part of this. And I think that sort of frames our discussion of it today, just the reality of it. So I guess with that, I'd open it for conversation. So let me ask a more direct question. If we remove wills from this, is there still is enough interest in the committee to spend the time to work this out and propose it as a statute that would reach, still a considerable number of documents of considerable importance. Again, without wills. Is there still interest in the committee in doing that? Are you all on mute?
Lane, this is Judge Cobb, and I guess my hesitation on some of this is I don't know that I have enough background or information to comment on some of these to see what the downside would be or the concerns that would be. Is there any effort being made to reach out to, I don't know, the medical community or people who deal with some of these paternity issues, transfer, recorded brand, those kinds of statutes that you're referring to?
Your question is there an effort to reach out? Not at this point. I think we thought we would, this group has considerable experience, and I would assume many of us have been involved in at least some of these documents, and among us, probably just about all of them, to have a sense of how this works. I would say in my conversation with Judge Burton that, at least she said at least she would not oppose the bill if wills are taken out. So seem to have some peace, at least with the rest of these documents that I assume she sees from time to time. She didn't say that she would support it, but she said she wouldn't oppose it. And she seemed to be comfortable with the rest of these documents left in. But that's just a report of my conversation with her.
Sure, which makes sense. I just didn't know if there was some expertise that we would be missing with regard.
But at this point, I think we're relying on the collective experience of this group to have a sense of what these documents mean and do.
My question, if wills are excluded based off of discussions on the listserv, I'm pretty confident that wills have been witnessed, at least with one remote situation. If we exclude it, could they still bring that will under the harmless error statute if that was the only way to get to address somebody's donative intent and create their testamentary wishes? If we exclude it, are we saying that courts cannot consider remote attestation of a will to fall under the harmless error?
So we discussed this in the last meeting, and the suggestion from, I can't remember if it was Judge Burton or Judge Cobb, was to add a provision that says explicitly that nothing in the remote attestation bill affects the ability to bring a will under the harmless error statute. Something language to that effect that clearly states that and or restrict the options available for executing a will.
Okay.
Yeah, I think that would be important. And for belt and suspenders, we might have that language in the bill, and then maybe a comment in the report as well. And that's an important point. We wouldn't want to, if we exclude wills, we wouldn't want to then somehow create an impression that we are excluding remotely witnessed wills from consideration under the harmless error statute. So
thank you.
That's a good point.
Is there a benefit to having this laundry list in 6 at all, or should we just not specifically address any of the things that this is meant to do, and just if it's witness or attest under the law, it's witness or attest under this statute? I feel like the list starts creating far more problems than it's helping, but I don't know why it's there.
That's a good observation. I think we would still exclude wills though, right? You'd have to. But so basically then this would be applicable to any document that requires witnessing except will.
So this is Gretchen. Perhaps then what we do is that we just have exclusions rather than inclusions.
Yeah.
Yeah, so I included the laundry list because I wanted there to be policy decisions made on each of these so that there's not something hanging out there that suddenly you're surprised that, oh my gosh, this actually applies to, you know, death with dignity, or this, you know, making that decision. So we can move those around, but I did want everybody to really take a close look at each of these options and make that decision.
Okay.
And with more, I mean, we can present it as is to solve a problem, an interim problem. And if there is like somebody who we didn't think about, or somebody feels very strongly about it, then they can address it at that point. But at least this is out there to deal with this issue that we're dealing with right now. That's
Or
just my thought.
You could do it as an including but not limited to, I would assume. Lorianne?
Yeah.
It actually does say that right now.
I'm sorry. Okay, I put it down. Okay. But yeah, but Chris's question still is then it does call attention, but Lorianne says that was her intent, at least for our purposes. I guess, you know, we can decide whether we want to leave that list in there or once we've given consideration to it. But I want to have some conversation first generally about the approach. I'm not hearing any objection to moving forward, at least with consideration of this draft, under the assumption that the wills are out. And if that's the case, then let's go back to the beginning of the draft and work our way through it. So, starting in section 1, we have it's the same definition that we've had before, right, Lorianne?
Yes.
And section 2.
Okay, this is Judge Cobb. Can I?
Yeah.
Oh, I'm sorry. Never mind.
But, okay, all right. So then section 3 gets into the new mechanics. I should say subsection 3 of sub 1. So let's walk through that. The writing the person executes or acknowledges any electronic presence of witness is validly witnessed if, in addition to any other execution formalities required by law, all of the following requirements are met. A, while in the electronic presence of the witness, the person, and that's language we've worked at before. Here we have presents a valid photo identification to the witness if the person is not personally known to the witness.
And this is Judge Cobb. My question is, what is presents? And then what's a valid photo identification? Can I just flash my gym card? Shouldn't that say government issued? Photo identification.
Isn't there a definition of identification in the notary statute that we could borrow?
I do not know the answer to that off the top of my head.
Mark, do you know offhand?
I've got to look through my stack of stuff here in just a second.
I'm going to look it up. Lane, I'm going to look it up as well.
Okay. I'm guessing there probably is.
It's ORS 194-240.
Thank you, beat us to it. What is it, Gretchen?
A notarial officer has satisfactory evidence of the identity of an individual appearing by means of a United States passport or a driver's license or identification card issued under the Oregon statute, or a comparable provision in another state that is current and not expired, military identification card, an identity card issued by a federally recognized Indian tribe, or other document issued by the federal government, state, or county that is current and contains signature and photograph of the individual. So it's pretty specific.
I'm comfortable with just tying it to that definition. That's pretty all-encompassing.
Consensus around that? So Lorianne,
I would agree.
That would be just by reference to 194. Who is that wants to speak?
But that was just me. I just said I agree. 194-240.
All right. So let's try that.
And did we address Judge Cobb's question about what is presents? How do you present it? Do we need to address that?
Well, that was my question. We're in the electronic presence, and that means that we're able to communicate in real time to the same extent as if we're physically present in the same location. Seems to me if you tie those things together, presents kind of takes care of itself, doesn't it?
Well, if you were in person, how would you be presenting that
I'll pull it out
identification?
of
That
my
language
wallet
isn't
and
there. You're just showing the notary that
Right.
license. So
Pull
I
it
don't
out of
think
my
it doesn't
wallet
even.
and I hold it in front of you and you look at it and
Yep.
yeah.
Yep.
Well, if you were in person, you could hand it to the person and they could hold it. So you can't do that electronically. So
Right.
you could-
But obviously that's a limitation just of the
Yeah.
of the
So
circumstance.
the other word that you, I think
What's that?
the only other word that makes sense is shows,
Shows.
displays, or displays.
Yeah. Yeah, that's a thought. Displays or shows. Lorianne, do you have a preference?
No, not really.
How does that work though if you have someone who might be sight impaired? Or-
Yeah.
I don't think it does.
So that's why I kind of like the word presents, because it kind of it goes back to the first statement about how as if you were in the presence of somebody.
How would it work in their presence?
Yeah.
But are we saying that a sight impaired person can't be a witness?
Well, how could a blind person verify your identity?
I don't know. I'm
Yeah.
just raising it because we've talked about making sure that we're inclusive with this.
Yeah. There may be a limitation on our ability to do that. I mean, can a blind person be a notary?
I think from a witnessing perspective, there's not a problem. They identify people by voice
Right.
as part of their standard going about life. So I think if you've got a personally known, you don't have a problem. I think
Right.
the ID does become the issue.
Yeah. And this presentation of ID only comes into play if you don't know the witness. So I think, yeah. So if you have personal knowledge between the witness and the person executing the document, I think someone who's sight impaired could probably do that. If not, I think you probably couldn't.
So if the testator is sight impaired, then someone else has to be there with them to attest who the witnesses are?
The only identity we're requiring to be proven,
Right.
as I'm reading it, is the identity of the
witnesses.
Yeah.
signer.
That's right.
But if the testator is sight impaired,
Right.
as many elderly people are, is it the testator who is identifying the witness or some third party?
Nobody's identifying the witnesses. I'm
Right.
understanding the statute. The signer, because we're taking wills out of this, so it will never be a testator.
Right. Right.
Signer.
Okay, all right, the person who
I
is,
am Joe, and people are signing saying, I saw sufficient identification that this is Joe.
Yeah. So it's the person signing who is presenting the identification to the witness, not vice versa.
okay.
So with those considerations, well, I guess, let's see.
You know, guys, let me talk to my commission for the blind to see if they have any suggestions on this.
All right.
And then I can let you know.
Okay. Well, let's leave it as present now. I think that's broader. I think it's generally understood. It's hard to misunderstand under the circumstances. But let's flag it as something we want some clarification on then. Okay. And then executes or acknowledges the writing. So that is the person signing the document, executes or acknowledges. And then C, delivers or causes to be delivered by facsimile or electronic mail to the witness the executed signature page.
This is Jennifer, and I had a couple of comments about that subsection C.
Yeah.
First of all, it would deliver to the witness a copy of the executed signature page. It would seem like you'd need that. In other words, not the original, obviously.
Right.
The other thing that I think is I deal with clients who are trying to send me things all the time, and very few of my clients have a scanner and even fewer have a fax. And so what they want to do is send a photo. So I could see somebody sending a photo by electronic mail. Is that what you're anticipating? Because sometimes photos of documents are very hard to read.
Yeah. Well, I guess it could be. They'd have to be able to print it though. One of Judge Burton's comments about this is that these requirements are probably going to be a roundabout way of really involving lawyers in this for the most part, without saying so expressly. But maybe not. I mean, I've got a printer at home. If I wasn't a lawyer, I'd still do this. But what do we think? Jennifer, as to yours, I think the language about delivers by facsimile or electronic mail is correct. I don't think you're not delivering a copy. You are delivering the document by fax or email. And it's the original one that you are transmitting and not a copy of it. So I think that language is okay.
Oh, I have one other question that occurred to me too. Because they're in the presence, does that mean that they have to see the faxing or the emailing?
I think the intent is that the faxing or emailing occurs while the call or whatever the electronic communication is happening. So I don't know. Do we need to get that specific?
I don't think so. We could certainly, with a comment, we could, that if the witness has to step away from the computer screen to retrieve a document from the printer, that doesn't break the electronic presence. I think I would rather do that in a comment than try and get that specific in the black letter, but it's probably worth pointing out because somebody would raise that question in real life at some point, probably. What do we think? Is this doable? Would we use it? Would people use it? Okay.
Yeah, they would.
Oh, okay. Thanks. I just saw the chat there from Sandy. The definition of the identification. Okay, well, let's go on. So the witness signs, as the person signing the document signs, they transmit the document by fax or email. The witness retrieves it, signs it, and okay, well, first of all, the witness still has to be in the United States, and then the witness attests the execution or acknowledgement of the writing by signing the transmitted copy. So now we have a fax signature or an electronic signature and a wet signature on the document. And then under C, B, capital C, sends it back.
So if it's being done electronically, can it be docu-signed as a witness?
Oh, that's a good question.
One thing, this is Sandy, one thing I was just looking at is if you take a look at the definitions that are in the the new Relona statute that's hopefully going to be in the special session, that they might be helpful because it's a lot of different definitions that deal with how to interact remotely through communication.
We're in the process of selling.
Try that again, Sandy. I couldn't quite make that all out.
I was just thinking, I was taking a look at the new, actually, hold on, I think I'm going to mute someone. I was taking a look at the definitions that are in the new remote notary statute, and it might be worth taking a look at those when we're coming up with the definitions for this bill, because I think they're applicable, and they incorporate all of the same principles that we're going to be using here.
Okay. Okay. So we've done it. We've signed. We've got the ID if necessary. We've signed. We've transmitted. Witness has signed. Transmitted back. That part is done. But we're not finished. The person signing completes a declaration of electronic presence. Now, and not later than 30 days. Okay, no, let's stop there. If we have the process in D, where we have original signatures ultimately on the signature page or on the document, do we need now still the declaration?
I think it would be helpful to have the well, in my opinion, and maybe consulting with the judges would be a good idea on this, but I don't know how you would otherwise know that this was witnessed using these provisions if you don't have some sort of declaration indicating that. Because by the time you get through, and we'll get through D, but the document that you're going to have signed, there's nothing on it necessarily that will indicate that it was remotely witnessed.
Right.
Lane, this is John.
Yeah.
I'd go the opposite. I'd go the opposite direction. I would delete A and B, because if you're trying to execute a document that needs witnessing, it won't be effective until you have two instances of snail mail back and forth. I think and then in the end, you wind up with a wet ink signature from the witness on a document that was not physically witnessed by the witness. So you still need the declaration. I just delete A and B and just require the declaration to be completed within 30 days.
Wait, which A and B are you referring? There's a lot of them.
D, A, and B.
Okay.
I'd delete the requirement that the original go, and I wouldn't want to give up the original. You know, what happens? You go through all this trouble,
yeah,
and then the gets lost in the mail.
Good point.
And now you don't.
That was that came out of the New York statute. That's why that's there.
These belt. It might just be belt suspenders.
Yeah, but it's a good point. It slows the process, and you're right, you're giving up a page of an original document that's going to have to make its way to the witness and back. And it could be two witnesses, depending on the nature of the document, I suppose. You might have to do that twice. Committee, what do we think about eliminating, doing what John suggested, eliminating the transmittal of the original document and just relying on the declaration, so it's still an either or, but in this case, take out the transmittal of the original document and just rely on the declaration.
Well, this is Jennifer, and I think that's a good idea because I was concerned of, what happens if that didn't happen for whatever reason? They got put in the file or something and then it never happened. Does that invalidate it because that step didn't happen? So I think it's better to just leave A and B out as well.
Okay.
This is Judge Cobb. I was in agreement with what John and Jennifer were just talking about, plus the fact that it kind of worried me that you're taking off a page from the document, kind of floating it back around, and it's like That seemed a little dangerous to me.
Yep, I agree. I mean, who wants to just?
Lane?
Because New York does it. Yeah, let me get back to my picture screen. I'm toggling back and forth between the bill and, who was it? Who was speaking? Who said Lane?
It's Kathy Belcher, and she's on mute.
Oh, Kathy. Oh, there you are. You're on mute. Sandy, do you need to help her? Oh, there you are. Okay, you're good.
Okay, as I was reading that A and B, I was not thinking that you were giving up the original document. If you sign the document, you have your original signature. You're sending it to the witness. They are signing. So what you're getting back is their original signature.
I don't think so. I think you
No?
are sending.
Because you're sending it
written, it says there's-
electronically.
No, under D, you're not sending it electronically.
Right. As
Yeah.
written, it's saying you send the signed original signature from the document to
Right.
the witness to add their signature to, and then mail it back to you.
So in this scenario, that electronic signature is really just kind of provisional.
Okay.
But I'm taken with John's notion of removing A and B, so we just rely on the
Agreed.
declaration, and then that it solves the issue of clearly identifying this as a document that has been witnessed electronically, remotely. Are we good with that? I like that. I think that's clean, and it also saves a lot of time.
Okay.
Done. So we
So
will
this-
eliminate. We will.
Do we
eliminate-
have no later than 30 days? Then if we're under C, the declaration, does that invalidate it? If you don't have that within 30 days?
Well, let's. I don't think we've decided that.
But the two declarations are included up in 3 that they have to be signed while we've still got our presence
Right.
going on.
No, actually, they don't. The way that it's now written, that's the way the prior version was written, but the way that it's now written is the only things that have to be done while you're on the call with each other is to have the actual execution of the document and the signing of by the witness, not necessarily the declarations. So that's a policy decision. Do y'all want to make it so that the whole thing has to be done while on the phone with each other? There was some concern about that last time.
I guess I sort of like not mandating that all be done at the same time. But then we do have to put a time limit within which I think it should be done, and maybe 30 days is good. It certainly provides time. Yeah, John.
I think you don't have an effective document until you get those declarations.
Right.
But you can't do them simultaneously and have immediate effect. So
Oh yeah.
it's up to you. But what's in comparison to the A and B thing, this is better because you don't give up the original document.
Right.
It's an additional document that comes later, and it can. So I think this is fine. The only way you could make it simpler would be to eliminate the declarations altogether.
Right. But I think the judges, and I think there's good reason for the declaration.
Yeah.
Everybody on
Would a solution be to include a statement saying the lack of receipt of the declaration within 30 days does not invalidate the attestation?
If we do that, do we need the 30 days then?
Did you need a declaration at all?
I think if we're not going to do the exchange of the wet signatures, a declaration is probably a good idea. I'm thinking here for enactability.
Personally, I think it's fine. It's just more paper you put into the same ceremony.
to do it all at once?
Yeah, I would. I wouldn't want to go back and do it later. I'd just do
Sure.
it all at once and make sure it's
So-
all done.
So then, John, do we leave the not later than 30 days and just leave it to, to people, best practice to be to do it simultaneously?
Yeah, I'm okay with that because you got to get the problematic one is the declaration of the person signing the document. That's the one that's critical. You got to do that right away. You can't very well you can't very well have somebody sign something, have somebody remotely attest to it, and then tell the signer, okay, well, in the next month, would you please send me this declaration back? You do it all right then and there. And then you just get the declaration back from the witness within 30 days.
Well, it sounds to me like you're talking us back to where we were last time, then that the declaration be done at the time of the witnessing.
Well, the 30 days is fine.
Okay.
But you can shorten it by doing it simultaneously.
Yeah, sure. Anybody have a strong feeling about that? Leave the 30 days in. And certainly best practice would be to do it at the same time.
Well, this is Jennifer, and I guess I don't have a strong feeling one way or the other, but if it's not done in 30 days, then is the document invalid?
That would be the case. It would be.
Because I sort of think, about like the affidavit of attesting witness. Sometimes you do that, years later.
Sure.
But we're not, those wouldn't be at issue here.
Right. But
Because we're not
it's the
including will.
practice of witnessing something long after the fact. Or not witnessing, but attesting to the witnessing. Well, I'm
Well,
trying
you're
to
not
get a
gonna-
sense. Do we want the time limit, or do we not? I guess the choices are go back to what we had and say that it has to be done the same time as the witnessing. Sounds to me like we're probably not there. The next is give a time frame to do it so that there's some reasonable association in time with the witnessing, and 30 days is as good as anything, or no time limit, and that's our policy decision. As long as the witness can remember that they did it and execute that declaration under penalty of perjury, they can do it anytime after.
My question, what makes this kind of hard is knowing exactly what type of documents will be using this type of scenario, and if
Sure.
timing is an issue. And the fact that, historically, if you have someone sign a witness and that's all they do is sign their name on it and there's no other further follow-up, wills are different and those are outside of the scope of what we're talking about today. Is it necessary to add this other piece of paper, or are we just adding an extra hoop that kind of prevents the ease and reasonableness, or putting an extra burden on a witness situation that ordinarily wouldn't require these extra belt and suspenders? Is it necessary, without knowing exactly what we're talking about, specific instances, like an advance directive? If you have two witnesses, all you do is have people sign it. You don't have them, you don't provide witness information or anything. They just sign it.
Right.
How does, are people not going to honor that advance directive until they see some form of declaration after the fact?
Well, the answer to that, at least the way this is drafted, is yes, they would not honor it until they see that declaration.
Is that are we serving the best interest in that scenario?
Well, I think the trade-off there, and I'm not arguing for it necessarily, but the trade-off I think was that this kind of witnessing doesn't have the same degree of certitude that in the presence witnessing does, and so the trade-off there was, the balancer there was to require this declaration. Otherwise, how do you know that it was done in the electronic presence if you don't have a certification under penalty of perjury? How do you know they've complied with the particular requirements?
Lane?
Yep.
It's John. The alternative to the declarations is putting a legend on the document itself that says that it was witnessed in accordance with the remote attestation statute. And I think we discarded that and opted in favor of the declarations a couple meetings ago. But you got to have one or the other.
I think especially since this is going to be new and used in emergency circumstances, that giving all the third parties of the world that have to recognize this, giving them some assurances, wouldn't that make it more user-friendly as opposed to everybody kind of wondering what in the cat hair is this?
Thoughts, anyone? My sense is we probably buy more support for this if we, and I would be comfortable in taking out the time limitation within which a declaration has to be signed. That may be just a trap. So we require the declaration, we eliminate the requirement of the exchange of the original, but we still leave in the declaration. I guess, as Judge Cobb said, this is new and different, and maybe we need some additional level of assurance that this was done, in a manner that was authorized by this new statute. Can we live with that? So that would be amending.
Can I ask
oh, go ahead.
Can I ask a question to clarify it? The no later than 30 days. If you take out the 30 days,
right?
One of the benefits of that no later than 30 days language is that it makes it clear that the declaration could come subsequent to the execution. So we'd have to preserve that, I think, to say that after the execution of the document, the witness and the declarations are executed.
Yeah.
So they don't have. So it's not required. So it's clear that it's not required that all that happened during the electronic presence time.
And I wouldn't say after, because that we also want to make sure that it can be done at the same time. So maybe at or after the time of execution. Or
yeah.
Yeah.
Do you want to say something like within a reasonable amount of time or something, or just leave it any time at or after the execution, the declarations are completed?
I don't know. What do people think? Reasonable, I guess, is give somebody some reason to argue about it.
I think that it's implicit that the question that comes before the judge of whether this is a valid witnessing is whether it was complied with in a reasonable amount of time. So I don't think reasonable adds anything really to it.
Yeah, and I'm thinking if it's an advance directive and you're presenting it to a doctor at a hospital, I don't want them trying to determine on the floor whether this witness attestation or the declaration was within a reasonable time. So I agree with Mark. I think we just leave that out, and then if somebody wants to argue about it, they can argue about it. But I don't want to necessarily give them that argument by creating a vague standard.
Well, to accomplish what John had said about making it clear that it can come after, you could indeed eliminate no later than 30 days. And then, so then it would just state following the execution or acknowledgement, you eliminate date of, then that, and then include what is now the witness completes the declaration. Yeah.
Yeah, and my only amendment to that was actually to say at the time of, or at the time or after, so that it's clear that it can be done contemporaneously with the witnessing. Technically, it might be 30 seconds after, but I think it'd be clearer if we say at the time of or after the execution or acknowledgement, the witness completes a declaration of remote attestation.
Lane, I like your wording better because it makes clear it doesn't have to be in the electronic presence. Following the execution doesn't necessarily mean a month later. It can mean like in the same session.
Yeah. So you like something like at or after the time?
Yeah.
Okay. All right. I think we've accomplished something there. Lorianne, have you followed all that?
Yeah.
Okay. Good. Let's go to 4, which is the declaration itself. We've got in the document a definition of electronic presence, just so and I think I asked for that, I think we assume that the witness doesn't know the statute. And so when they say they signed it in electronic presence of, they really don't know what they're saying. So by including electronic presence, we're telling them what they're attesting to. So we got the name, we got the date, the place, the state. Do we need the time?
It seems like having the time in there could create, because I think both of these have the time, that could create a disconnect that could cause problems if the witness and the person signing the document don't have the same time on there.
Right. Or if the witness is in New York and the person executing the document is in Oregon, and now you got 3 hours difference, and what is that?
Especially since the declarations don't necessarily have to be completed while on each other. So
yeah, so a week later you think, oh, what time was that? Okay, so let's take out time. So the first one is the signer's declaration. So I signed, see, this would be attached to, let's say, an advance directive. And so this is the signer signing this. I signed it in the presence of so-and-so. And they sign.
Do we need to have the potential of multiple witnesses identified there?
I don't feel like we need to put that in the statute. That I think that that's understood, that if you have more than one witness, you would add more than one witness's name. But if you do add it in there into the statute, it could be interpreted to mean that you do have to have more than one witness.
Well, just using the example of an advance directive, I think it requires 2 witnesses.
Right, that's the point, is that an advance directive does require 2 witnesses. So in the advance directive form that's in statute, it has space for 2 witnesses. But where this could be attached to a document that only required 1 witness.
Right.
So if we have in the form a space for 2 witnesses, that adds an ambiguity. If it's remotely witnessed, does that mean that it requires 2 witnesses, or can it only have 1?
Understood, concede.
What if after the word name we put an S in parentheses? Isn't that kind of a typical way of showing it can be singular or plural?
We don't actually like to do that in statute.
Okay. Yeah, I mean, so one of 2 things would happen. Either one of us who's doing this would doctor the declaration and create 2 signature lines, or you could have a separate declaration, I suppose, for each as to each witness.
Well, the other thing that you could do is under 4A, you could refer to multiple witnesses or something.
Of course, 4A is
the language right before the declaration.
Right. Or you do, or you do that in, let me see.
What if the parenthetical says names of all witnesses?
Or maybe witness or witness's name. No, but then, oh, Lorianne, why don't you do parentheses, S?
Why don't we? Like, are you asking a question of why?
No, that was more of a
avoid?
That was more of a complaint.
Okay, yeah. I mean, we could be specific in 4A to say that, if you want this to be completed for each. Personally, I don't think that it's necessary to get this in the weeds with it, because it's in substantially the following form. It doesn't say that it has to be in exactly this form.
Sure.
What if you just said witnesses or witness name or names? Because cover.
This is Gretchen, and I guess I'm seeing that in the beginning it says the relationship of two or more individuals in
Right.
different locations. So it's already implied, I think, and so that we're talking about potentially more than, you know, one person or two people type of thing.
Yeah, I think I'm kind of inclined to agree with Lori Ann. You may have a situation where one of the witnesses is remote and the other one isn't. And just sort of let this work out. If you've got two witnesses, you're going to have to have a declaration of each witness. And can we live with that?
Elaine,
Yeah.
I've been figuring out how I would make this work. And it's fine the way it is, I think. Here's how you make it work.
Okay.
The signer's declaration references the foregoing document.
Right.
So the way you make that work is you type this at the end of the document below the signature line.
If there's room, sure.
Or you create, somehow you've got to do that because it's not an attached document. It's not an identified document. It's a foregoing document. So it's got to be written in, stamped in, stapled to, or something.
Yeah.
The actual document that the signer signed.
Right.
Witness's declaration refers to an attached signature page.
Mm-hmm.
And you'd make that work by having because you've electronically transmitted the document to the witness who has signed it.
Right.
And then transmitted it back. So the witness still has the document the witness signed.
Yes.
So the witness signs the declaration, staples it to the copy that they have, and then you send that back. So that's how you work.
Yep.
Works just fine if you do it that way.
Okay. And the issue of one or two witnesses, I guess we leave it to the person signing the document to figure out if there are two witnesses. They need either put two names in that blank, or they sign a separate declaration as to each witness. But either one works.
Right, and then you got two witnesses, and they each have their own signature page.
Yeah.
So
Right.
So this is workable.
All right. Anybody else? So we're gonna eliminate the reference to time in both of the declarations, but otherwise go with those. Okay, and now we're into section 5.
Can I ask a question?
Yeah,
Is there any
sure, of course.
concern about this simply saying forego document, or the foregoing document,
Yeah.
and not identifying what the document is? Because my understanding is we've got a whole laundry list of possible documents here. Should there be anything that identifies this as an advance directive as opposed to, I don't know, a life settlement contract or any of the other things here?
Well, that'd be easy to draft if we wanted to, just to put the foregoing document and then a blank with in parentheses, say insert name of or add name of, or just no name of document. I don't have any problem with that. Okay. See how easy that was? All right, so going to 5. I'm bound and determined to get through this thing today, and maybe even talk about e-wills. But and we're getting close. 5. Writing witnessed in. Okay, do we need the counterparts now? I mean, doesn't it sort of speak for itself what it is?
I think that so this is Lorianne, and I brought up whether we needed the counterparts when we were having the witness sign the original, after the fact, sign the original signature page.
Right.
But now where we've got the declaration is really the only evidence that you have that it was remotely witnessed,
Right.
that probably be a good idea to have those counterparts to bring that declaration into the document, would be my position on it.
Anybody have an opinion?
I agree.
Okay. All right, we'll leave it in. Now.
Lane, can we back up? Lane, sorry.
Yeah. Yep, Matt.
I think we need to touch on something on the witness's remote attestation declaration. The last clause says, and that I thereafter signed the original signature page.
Oh, yeah, thanks.
That probably needs to come out.
You're right, thanks. That's a vestige of what we took out above, so that does come out. Good catch.
And the time, I signed my name as witness, the foregoing date and time. I thought we took out time.
We are taking out time, yeah, on both of the declarations.
Yeah, you gotta take it out there too.
Good.
Do we want to have a reference to the document title in the witness's declaration as well? I think it'd be easy to drop that into just as an additional check and balance. Does anybody object to that?
I think it's a good idea for the same reason that we have that in the page about the signer of the document.
Something else to just tie the two together. Yeah, that's a good point, so that you can't take one separate declaration and attach it to another document. All right. So we'll make those changes. We're leaving 5 in. And then we get to subsection 6. You know, what's everybody's thoughts about this? I think Christopher made the suggestion that we that we just include any document that requires witnessing except wills. Lorianne said she would included this just so we would know. What's anyone's?
I think it may be useful so that the legislature gives it some thought. They're the ultimate policy deciders, and if the legislature thinks that one of these is not appropriate for this, then they could change it to make that clear.
Okay.
So my understanding, 6D would be removed, as
Yes.
well as capital B at the bottom of that page.
Yes.
But where will we put the position that any will that is signed via, of a remote attestation?
That would have to be a new section.
So something along the lines of a will witnessed through this section would be subject to the requirements of the harmless error statute?
Yeah, however, Lorianne, you'd write some sort of a savings clause there.
Yeah.
Nothing in this section, yeah, I think that's just a drafting issue.
Yeah.
The reference to capital B, I think, comes this statute doesn't apply to witnessing of the execution of an international will.
Right.
So B doesn't come out.
That stays, okay.
Oh, wait, what?
So he's talking about subsection 6, little b.
Oh, okay, right. Okay, so that's already an exclusion. Yeah, sorry.
So just to clear, maybe it would help to go through what each of these are. So,
we don't want to.
So we've got 6, little a, big A is a consent for autopsy. B, the consent regarding disposition of remains. C, the revocation of an anatomical gift. So E is the
that's a record of, so it's also included, it also includes the anatomical gift, doesn't it?
Yeah.
Okay.
Sorry. E would be an advance directive, the witnessing of an advance directive. F would be the witnessing of a declaration for mental health treatment. Then G is a request for medication under the Death with Dignity Act. H would be, and just to clarify, I don't know how familiar you are with that, the Death with Dignity Act, but the request for medication has to come at least 2 times in writing both times and be witnessed both times. So that's a big check and balance that the legislature intended to have in statute. Well, actually, the voters intended to have in statute. So that's kind of a big policy call. Then there's the consent for enrollment in a medical health database. That mostly has to do with if you've got a medical issue that you want public servants to be aware of if they come into contact with you. And then you've got to be honest, I can't remember what the written statement designating an authorized representative was. I think that might have to do with public benefits, but I'll have to look into that.
Well, it's in the paternity statute. It looks like it's in chapter 432.
Yeah, I'm not sure.
Okay.
Then so I'll look into that as you guys are discussing the rest of this, but then you've got the voluntary acknowledgement of paternity. This is something that is used for a lot of different purposes. So I think it would be helpful to contact some family law attorneys and make sure that, and juvenile law attorneys, to make sure that they want to expand the options for having that policy call is kind of a big deal. Then documentation of the transfer of a recorded brand. I'm not sure if you want to get that deep into it. Then consent to a life settlement contract would be, those are all of the instances that are in the ORs that talk about the need for a witness to a written document. And so that's why I called them out, because if we're changing what the requirements are for witnessing, those changes will affect each of these unless we specifically exclude them under the next subparagraph.
Do we have the background enough to impact G, big G, with regards to the death with dignity? I mentioned that only because I know that it's a contentious matter, as is some aspects of the advanced directive. And if we have a situation that requires 2 different witnessing periods, can they both be done digitally? And if we're concerned about fraud on a will, here's a situation that you really might not necessarily be able to overturn. Do we want to directly state it in this petition? Because without you explaining what that was for, I didn't necessarily know what it was referring to. And do we have anybody on the panel that's involved with or connected with the death with dignity aspects?
Well, I do know that there was a big push in the last full legislative session against, there was some clarification of the law in the last legislative session, and there was a lot of people opposing that. So I figure if they see this, those same groups probably would say no, that this isn't appropriate for such a serious situation. I'm just telling you, I think that there probably would be opposition to that, at least that subsection.
One option for continuing to flag this as a policy call that the Legislative Assembly needs to make would be to drop the reference to the death with dignity part of it into this does not apply to. And so that way it's still in there, it still flags it, but at least it's on the, we're not expanding it here instead of we are expanding it.
What's everyone's sense?
Lane, can I chime in? I think we ought to delete all of this. I think we ought to delete the including but not limited to in the entire list and just leave it applicable to any writing required by law to be witnessed, except,
right,
and add the exceptions that we want, the notarial acts, international wills, and wills. And if some interest group thinks that this is inappropriate for their little part of the world, then they can ask the legislature to add another exception.
Well, and let me just kind of expand on that. If we were to do that, I think for the purpose of presenting it to the legislature, we would want the comments to include the list. So, you know, I think it's fair notice to the legislature, but, you know, and that may be a middle ground. We include the laundry list in the commentary, in the comments, but not in the statute.
Yeah, these are all examples of situations where it would apply, but I don't know why you have to have that exhaustive a list in there. I've always, you know, including but not limited always bugs me because it's grammatically redundant, but everybody uses it. You know, including is non-exclusive. Nobody believes that, so they add but not limited to. So they're saying that they're just doubling down on the same concept, and people still don't believe it. They still think that if it's not in the list, it's not there. So I would get rid of the list altogether and just have it apply broadly to any document required to be witnessed, and have specific exceptions. So it's more like more like a release, where you release all claims that you have, except you reserve the following. So now you have clarity.
Yeah, let's talk about that. That's really the last thing that we need to resolve on this, and it's significant.
This is Gretchen. Sorry,
yeah, Gretchen.
Lorianne, I think part of the concern here is that we do want to have at least some sort of a list to identify for the purposes of letting the legislature make that policy decision of what it wants to include and not include. Short of doing the list as it is, not just the exclusions, but the including, not limited to, is there another way to, tag these lists that you created so that the legislature knows this is what this particular bill could touch?
Yeah, so what I would do if this was not being drafted for the Law Commission, I would have a transmittal memo that I would send to the person requesting it that said, hey, these are the policy decisions that you need to make. These are the things that this is going to affect. So I could do something similar to that the Law Commission can then provide to the Legislative Assembly. And actually, I don't know if Chana's on the call. With LPRO, because I think this is going to be introduced by the Judiciary Committee, isn't it?
I think so. I think it will be a Senate Judiciary concept. I think what the question is timing.
Yeah, so, this is something Chana and I can work on as well, because I think that in her summary of it, she can indicate what it is touching on too. But I definitely would want to have all of these things flagged for the Legislative Assembly so that the policy calls are made on each and every one of them.
Well, and what I suggested earlier, that, since this is a Law Commission product, it'll come with a report or with commentary. Yeah. And my thinking was we could just build that into the commentary so it's all in one place.
But I did include this in this draft for this group so that this discussion could happen. So if there are certain of these that you definitely do want to exclude, so in the exclusions right now, we've got, it won't apply to wills, it doesn't apply to notarial acts, it doesn't apply to international wills, and it does not apply to petitions that are circulated around for signature. So when you've got somebody going around that you bump into on the corner and they're getting you to sign petitions to get initiatives on the ballot or something like that, they have to sign something and they sign something saying they witnessed these signatures to happen. So that's what is specifically excluded in 6 little b big C.
And then didn't we just agree that death with dignity, capital G, goes down into that group as well?
Yeah, we can move that down there too. And then what I can do is take everything else out of the including but not limited to, like what John was suggesting. So it'll just be that subsection 3 of this section does not apply to, and then have the excluding list. And then we can all, between the Sandy and Shannon and I, we can put together something that the Legislative Assembly would see that would say, although this isn't specifically called out in the draft, these are the instances that this would apply to that are in statute right now that require witnesses. Does that resolve the concern?
And so in the special session, the legislature actually will consider all these? If
They'll
you
have the
call them,
opportunity to.
okay.
And I want to be careful that I don't want to commit anything to the special session. I don't have any authority to do that.
We
right
understand
now.
that.
We recognize that, Shanna. Thank you.
Okay.
So I would include 6a that just says it applies to any writing, and then have the 6b. So get rid of all the
Right.
listed ones, and then have a 6b that talks about it will not apply to blank. And then we have the special carve out for wills, that any will that is done this way is still permitted to be presented under the harmless error.
And I think there may be a good policy argument to do it that way, because as Judge Cobb says, we're really not expert in all of these documents, but there are people who are. And so what we're saying is we're not going to make the policy call, except as to those very specific documents that we know and we're, that we are experts in, and for either enactability or other policy reasons should not apply to. Otherwise, we're going to say it's everything unless somebody wants to pull something out. And the easy way to do that, if this gets introduced and if it gets considered, if there is objection to in particular one of these documents, an easy amendment to add to the list of exceptions. So a document is in unless it's out. And we're not making the policy call for each document.
I like that. I think that's a great idea.
Okay.
Do we have a long list or not?
No, it's not a long list. Of inclusions, it's going to be the non-specific language. The subsection 3 applies to the witnessing of any writing that is required by law to be executed or acknowledged in the presence of a witness, except as provided in the next subsection.
Well, sub B says notwithstanding paragraph A of the subsection, the section does not
Okay,
apply
all
to.
right. However that works.
Yes.
Yeah, okay. So it's
You can combine all that in one section. It applies to everything except the following, and list them.
That's a drafting issue. But okay.
You want my job?
What's that?
Go, Lori.
Just offering John my job. He can look at LC.
Careful, he'll take it. So there's, we got it. 6A is going to be, or however Lori sets it out. We will have a broad, inclusive statement, non-specific statement of inclusion of documents, and then we will have a specific list of excluded documents, which right now are the documents in. We'll add a will. We'll add wills. And then we'll have the Notarial Act, we'll have the International Will, and the petition circulator.
And the death with dignity.
Oh, wait, who said that?
I did. Lori.
I don't have the pictures on the screen. Who's I? Is that Lorianne?
Lorianne, yes, sorry.
Well, let's talk about that. Should we treat death with dignity the same way as we treat everything else we listed in the comments, and let the legislature make a call if they're, or do we think that there are good political reasons just to take that out and avoid the argument altogether? I'm not that attuned to death with dignity. Well, ever since I was in the majority in 1997, where we re-referred the death with dignity measure that had passed by a petition, and the voters actually passed it by a greater majority the second time around. So that taught us about re-referring measures to the voters. But I haven't anything to do with it since then. So what's the sense? Do we take death with dignity out just to avoid the battle?
Wasn't there someone? Sorry.
Sorry, this is Eric. I would include it as an exception just because it is a hot button one. And if we just treat things as status quo, the legislature can address it. If we leave it blindsided, then or if we don't put it as part of the exception, the argument's going to be that we're trying to sneak this by, and what else are we trying to sneak by? And I would just recognize that it's a delicate or sensitive issue, and put it in the exception with wills and notaries and petitions.
Sandy?
Yeah, just from a commission, trying to get our stuff passed perspective, I happened to be in a lot of those hearings during the last session. I think Gretchen was alluding to, because it was they were the same hearings as some of our other bills. And I would agree with Eric that is going to be a politically difficult position. I would also specifically place it in the exceptions.
I don't have a strong passion about it. Does anybody? I mean,
seems like we're really throwing people under the bus on something that could become drastically more relevant since we're facing a disease that causes painful, crappy death.
But you know, if the legislature feels that it should be included, they can easily take it out of the exception and put it back under the overall umbrella.
That's sort of the reverse argument. Either way, we're highlighting it. The things that we are including, we're going to list in the comments, so they'll see those. The things we are excluding, they will see in the black letter of the statute. And you're right, Judge, if they want to add anything to the exclusion list, they can do that. If they want to take something off the exclusion list, they can do that.
I mean, theoretically, they could take the wills off that exclusion list too.
Yeah.
Right? And so
I'd prefer to leave it in the comment, not put it as a specific exclusion, but I think that's from leanings and biases that probably don't fit the roles that this committee is meant to be fitting.
Right. I think it's a political calculation.
I do think it's kind of capitulating to a very small minority on how we run things instead of notifying the legislature, hey, if you care about this, it's here. Otherwise, we don't see a reason to treat this any differently than anything else.
So that's Christopher. Does anybody else want to argue for not excluding death with dignity?
Lane, this is Jana, and I'm not going to argue in either direction, but I'm happy to ask around and see what some of the appetite and flavor for including it versus specifically excluding it is from people who might be making these decisions down the road.
Okay.
And this is Jennifer, and I agree with what Christopher said.
Okay.
Shanna,
thank you for that.
Yeah. So we'll save this particular decision and ask Channa to shop this around. And Channa, do you think 2 weeks would be long enough to do that?
Sorry, that's, I think so, but no guarantees.
Okay. Well, I tell you what, for this, let's go ahead. I mean, it doesn't matter. I mean, because we're gonna have to address this again. Let's go ahead and not exclude death with dignity for tentatively, but subject to Channa asking around if it looks like it creates a problem. And if it creates a problem, then we just make a political decision that it comes out. And what our decision will be guided by basically what we think the receptivity would be either way. But like I said, I don't have a big, to be pure policy, I would probably have this apply to everything that could be witnessed, just because if we're saying that this is a good enough process, then it ought to be good enough for whatever requires witnessing. But we've already made the decision that we're going to have to exclude some things for one reason or another, and this is just another one of those decisions. So,
hey, Lane, to me, it's just a procedural thing. We're just responding to the pandemic and dealing with the mechanics of witnessing a document. We're not taking any position on whether the action should or shouldn't be taken. We're just dealing with the mechanics of a witnessing. So it's kind of benign, really.
Yeah, it's benign probably until you get into a legislative argument about it. I mean, I agree with you. I do agree with you.
Somebody could add it to the exclusion list if they have to.
Yeah, and I think that's, for now, let's leave it off the exclusion list, but let's ask Channa to test the waters on that and see if this is going to just make this become a big issue. And if it is, we add it. Or I don't think we need to make that final call today. But we've made great progress on this, and I think we're just about done.
This is Gretchen.
Yes, Gretchen?
This is Gretchen, and I really apologize for this, but I should have thought about it earlier when we were talking about what the identification is and referencing ORS 194-240. And that's the current issue we have because of the pandemic with the Oregon driver's licenses. People's licenses are expiring right now and they can't get them renewed. And so what the governor had worked out with the Oregon State Police and all the other police is that they weren't going to enforce expired driver's licenses. You know, they're not going to ticket people for that. Basically, you know, January, if your license expired in January for, you know, up to whatever, you know, if it's expired, then they weren't going to ticket you unless there was, you know, some other reason to ticket you. Or your license had been expired for 3 years or something like that. The issue that we have is that we may have people who have a driver's license that has expired. And while the statute gives an exception for expired not more than 3 years for like an out-of-state license, it doesn't have that same language for a driver's license or identification card issued under the Oregon statutes. So I don't know if, no, the way it reads is it says, or a driver's license or identification card issued under ORS 807-400, right, or a comparable that is current. And I'm not sure if that modifies
I think that comma means that is current or expired not more than 3 years applies to everything that comes before it. Lorianne.
Yeah, it would, because the comma's there, the last antecedent rule doesn't apply. So it would, that.
Does it apply to everything?
Yes.
Yeah, within the comma.
Okay. Then we're fine.
All right.
I just think people should, I mean, I think that's something if anyone asks, we do need to be aware of that there could potentially be people with expired licenses, and that's not necessarily, I mean, if you're talking about, you know, the will situation or anything like that, if somebody's shown an expired license, that's not necessarily an you know, indication of fraud or anything, particularly with the pandemic right now.
Sounds like a good CLE topic.
Why does the expiration of the document change your identity?
Well, I don't want to relitigate that issue. That's already in Chapter 194. I don't know, but there it is.
I mean, you're still you. You're still you. You're not a different person. License.
Your cells were different 3 years ago. You're not that same person you were 3 years ago. I think we're there. Let's talk about Section 2 for a second.
The changes in formalities and difficulty of getting identification, especially as Oregon's switching over to a harder to obtain, harder theoretically to forge ID.
So I'm sorry, what was that, Christopher?
I think the argument would have more to do with improvements in anti-fraud and the creating identification cards and making them harder and harder to duplicate inappropriately.
Yeah.
You mean real ID?
Mm-hmm.
As one example, yeah. So the argument for not taking more expired ID is that the older the ID is, the easier it was to fake that card.
Yeah, although we had... I don't want to create a different definition for this statute. We've got one that is in, and I don't want to try and amend that either. So let's just go with it.
Yeah, no. Now that you've, as long as that's clarified, and I'm okay with that. That was a concern because I didn't want somebody not being able to do it because somebody goes, oh, your license expired, and they can't get it renewed right now. They literally can't get it renewed.
Right. So let's go to Section 2, and here's my only question. Do we want this to be a temporary law, or is there good policy reason that we not associate it just with the pandemic, the declaration of emergency? Section 2 repeals it 2 weeks after the emergency declaration or any extension of it. And my question to the group is, does this still serve a policy purpose that would be a benefit to make this a permanent statute? I mean, for all the trouble we've gone to.
It seems to me that if we have this under the emergency basis, And if it, everybody thinks this is great, it can be reintroduced at the regular legislative time when we're not looking at emergencies, because, just from all the legislation that we did with the probate modernization group, there was things that we hadn't anticipated. There was all kinds of tweaking language that had to occur. It seems to me to be prudent just to have this as an emergency basis. And then if it's necessary, take it to the legislature that makes it permanent later on.
Thoughts?
This is Ken Sherman. I thought we were told earlier that the emergency or that the special session, when and if it occurs, would only deal with emergency matters, and that I'd be really surprised if they opened that special session up to other matters that might be of more permanent.
Well, I don't know, Shannon, maybe you can answer that, but of course, if the notarial remote notarization goes in, that's a permanent statute.
Right.
Is that a hard and fast rule?
No, this is
No, it's not. It's not.
Yeah.
Okay.
So the notary would, in LC 29 or whatever iteration we're on right now, would have a repeal, and it would need to be brought back in the next session. And the direction that I've had from leadership is anything that's intended to come through a special session that addresses the current emergency will have a repeal on it. So
how about
if
if we do,
it comes in 2021, you can have it apply across the board forever. But if it's coming in the special session, it contains a repeal.
Then how about, folks, if we do that? So this will have that same repealer in it, so it may extend beyond the emergency to the end of this year and into whatever date they're adopting otherwise for that automatic repealer. Can we do that? Seems to be.
Would you repeat that? I didn't understand.
Yeah, this would have an automatic repealer in it, but it would be the same as the other special session statutes, which, as I understand Shannon to say, would extend it into 2021 so that it could be reenacted by the next session and made permanent that way, but it wouldn't be repealed before. Is that the way it works, Shannon?
It depends on the item under consideration. There are a couple of the components that deal with court-related processes specifically that are extended into 2021, I believe, so that they remain in effect through the long session. But there are many, many others that are repealed promptly at the end of the emergency period. It depends.
Okay. So our choices then are either to go with Section 2 as drafted and fall within that group that does repeal at the end of the emergency, or to go with the other group that extends to the end of the 2021 session, so that we don't have a gap, I guess, in that case, if the legislature wants to reenact this and make it permanent. What's the preference?
This is Mark. My preference is to go with the second alternative there, that it has the quote standard repealer and can be reenacted in the regular session
without a gap of applicability.
Correct.
Yeah. I like that.
Do we also want to include some kind of language here that notes that documents executed within the window that this was valid are valid even after this bill sunsets? Because I can definitely see some squirrely beneficiary or somebody that wants to fight a document popping up and saying, well, we're past that window, so it's not valid anymore.
Well, that's a good question. When Lori Ann gets back, we can ask her that. That'd be, yeah, because clearly we want to make sure that that would not be the effect. And whether that takes special language to say that, yeah, that's a good question, Christopher. All right, anything else? I think we're very close to a finished product here, and I think it's pretty good. Lori Ann, welcome back. Question.
Sorry about that.
If this, do we need language that says that if this bill goes away, if it's repealed and is not reenacted, do we need language that validates any document that was signed during the effective period of this statute, so that it's clear that those documents don't become ineffective?
No, we do. That does not need to be in this.
Okay.
Because it would be if when something's repealed, if that doesn't retroactively get rid of things that were executed validly during that time.
So Susan, maybe we could have a comment anyway, just to clarify that that is the standard legislative interpretation, so that if somebody does think about that, they'll have a clear answer. But I agree. Okay, good. Well done, everybody. So we have Jana, who is going to ask around about including death with dignity, and we have the possibility that we may pull that out if it looks like it's going to create a buzzsaw effect. And otherwise, was there something else we were going to come back to?
We had Gretchen that was going to check on with the Blind Commission on proof of identity.
Right.
Yeah. And at this point, my client actually she got back to me right away and says that in Oregon, a large portion of people who are legally blind actually can see enough to be able to make those identifications. It's a small segment that can't, and I'm just followed up with her. I haven't heard back from her on the other question, which was, is there something, any language or anything that you would recommend? So I'll let you guys know when I hear on that.
Good. All right, congratulations. We're almost there. Let's take the last 25 minutes for an introduction to electronic wills.
This is Judge Cobb. Before we go there, can I ask the question how electronic wills jumped the line in front of the procedure statute that we were originally committed to work on?
This is Sandy. I can say what happened was, just in terms of the mechanics of our agenda, is that we had done the initial discussion of 111. Then it was scheduled to e-wills, but in the interim came up this idea of potentially having a special session version of this attestation concept. So I have just always stayed on track that when we were finished the attestation, we were going to introduce e-wills before we went back to 111. The reason at that point, when we initially created the agenda this way, was because there was going to be some feedback time, some time to go back and redraft 111, which has been done at this point, but I've just been keeping the agenda as is as the attestation conversation's gone forward. But I can promise the 111 conversation has not been forgotten. That draft does exist, and if the group decides they'd rather start next meeting with 111, we could do that.
That's fine. And that's a good question, Judge. I think you're right. There was a sense at one point that we could hurry up and get the electronic wills in, and maybe as a special session adoption. I think that's unlikely, shall we say. So you're right. I think it's probably stayed on the agenda because that was a decision we made preliminarily, but I think we're not really serious about getting e-wills in time for the special session, unless special session just doesn't come until September or October or November. But we got 25 minutes. We don't have the 111 in front of us. Let's just maybe, Susan, if you could kind of put your law professor hat on and tell us about electronic wills. Give us the context.
Yeah.
And again, for anybody who may not know, Susan was the reporter for the Uniform Law Commission drafting committee that drafted the e-will statute. So is probably nationally just about the most authoritative expert that we have on electronic wills at this point, at least under the Uniform Act.
This is Jennifer. Just one other comment to add. We did discuss this kind of will back a couple years ago and decided not to do it.
Right.
And there's only 4 states who've adopted this. And so for me, I'd rather go under the procedural statute than get started on this.
Well, yeah, except we're not going to do that in the next 20 minutes. I'm just thinking we got time. It's on the agenda. and you're right, Jennifer. Of course, when we did not go to e-wills, we didn't have a uniform act, and so we may see more states moving in that direction because there is a uniform act, and I think I'm interested at least in hearing about it. So with that caveat that this is not intended to come to a vote of the committee before 12 o'clock. Susan, tell us about it.
Right, and part of what I can talk about is why we have decided to look at it now, and what Jennifer said is absolutely correct. We talked about it a couple of years ago and put it on hold, but a couple of things have changed since then. First, we have a Uniform Act, but I thought I'd explain why we have a Uniform Act. I did serve as a reporter. We had people from around the country who were involved in the process of drafting. And I would say most of the voting members of the committee don't like the idea of electronic wills. Most of them are have estate planning backgrounds, and most of them, the reaction was, and I'm guessing that would be the reaction of many people on this call, is, well, why do we need this? It's perfectly easy to print a document and have people sign paper, and we've always done it that way, and why do we need something different? But we do need to think about this because it's coming whether we want it or not. And by the end of our 2 years of discussion on the drafting committee, people were resigned to the fact that we do need this legislation. And that's for a couple of reasons. One is that a lot of non-lawyers think that they can do it already. There are a lot of people who do everything else online, millennials in particular, or people younger than that, but older people as well, who do all of their other business transactions online and just assume that they can execute a will electronically. And do that in an attempt to have a valid will, and then the will is not valid. In a state that has harmless error, the harmless error statute has been used. It was used in Michigan to give effect to a will that was typed on an iPhone. But it would be better to have a process in place that explained how to do this without having a court determination under harmless error. So one thing that's changed is the expectation of a lot of people that they can do this, and people will try to do this whether we have a statute or not. The second thing, and I see Heather is talking about LegalZoom, the second thing that has happened is that there are a couple of companies, LegalZoom is one, Willing.com is another, that would very much like to be able to provide, as part of the services they offer, in addition to the will drafting services that all of us have great problems with. But in addition to that, they would like to provide services for electronic execution. And an electronic will is actually what we're really talking about, is electronic execution of wills. Most wills are typed electronically to begin with. We then print them out and have the paper version signed. So really the statute should have probably been called the Electronic Execution Uniform Act or something, whatever that acronym would be, because what we're really talking about is electronic execution. And what Willing.com decided was, hey, we could offer this service, people would buy our will drafting program, and then we would offer a service that would do two things. That would allow the person to have this executed online. We Willing.com would provide witnesses and remote notarization. And then even better, because that's a one-time deal, you get paid a little bit, but not so much. Then even better, we would provide a service that would store the electronic will and charge a fee for that. And I don't know how their business model for that works and how they charge, but that was the idea. So Willing.com, the company, drafted legislation that they began taking around the country, introducing in a number of states. And the bills, those 4 states that have bills, well, not Nevada because it had an earlier bill, but they were influenced by the Willing.com bill. Now, what happened in Indiana, and Florida is that the estate planning bar got a hold of the bill and slowed it down. It didn't get pushed through the legislature in the first session. The estate planning bars pulled it out and they made revisions to it that kind of pulled back from what was in the original bill. The Arizona bill is pretty close to the willing.com version. Nevada is probably similar, even though Nevada had an earlier electronic will statute that nobody used. They now have a revised version. So those are the four: Arizona, Nevada, Indiana, and Florida. The expectation is there will be a lot more states with electronic will statutes. Not every state, certainly, but there will be more states, both because willing.com is going to continue to push, but also now we have a Uniform Act, and that will give states something to look at. When we went into drafting the Uniform Act, there were a couple of policy decisions that were made. One was that we didn't want to put a business model into the statute. We didn't want to create a statute that would require someone to use a particular business in order to have an effective will. And that's what that other legislation did. And so we intentionally didn't do that. The other thing we wanted to do as a policy matter is to try to tie the requirements as closely as possible to a state's regular statutory rules for a valid will. So the differences in the statute, what the statute adds on, are the differences that are required for the statute to be electronic. I mean, for the execution to be electronic. All the other wills rules still apply. So we didn't try to get into any of the other rules like undue influence or capacity or intent or those sorts of things. Really just focused on the attestation. And the thought is that if the Uniform Act doesn't match a state's attestation requirements, for example, then it should be conformed to match the attestation requirements. And so if there are differences, that's one of the things that we should do in Oregon. We also wanted the statute, and this is not the case in some of those states that have adopted something, we wanted a statute that would validate a couple of different types of wills. Where one type is the willing.com will, where somebody buys a will drafting program online, the process happens online, and the execution happens through the what's going on with the company. But we didn't want to require a company, and we didn't want to require a what do we call it? We talked about having an official blesser, I think was one of the terms, not officially the term, but to have somebody who would supervise the electronic execution that was going on. We decided we didn't want to do that, partly because we couldn't figure out who that would be other than a lawyer. We didn't want to put require a lawyer in the statute. But we wanted to be able to give effect to wills that people executed on their own without the assistance of a lawyer, as long as they meet the requirements of a valid will. I can, in California, write a holographic will, write it out by hand, signed it. It's a valid will under that state statutes. I could do that. In fact, one year I had students do that, write out a will, sign it, have two of my classmates sign it as witnesses. It's a valid will in Oregon. And so we wanted to create a process that would allow an electronically executed will to be valid without unduly burdening the person doing that by requiring some sort of business to assist. But we also had addressed a lot of the issues that have come up in our conversations around electronic attestation. We wanted to provide safeguards. And that was a big concern, obviously, for something being done electronically. And a lot of the conversations that we have had as we've talked about electronic attestation, particularly when we were talking about it in the context of wills, were the same ones that we had on the committee. How can we do this so that somebody's not standing, here I am here, and over on the side is somebody with a gun forcing me to execute my will here. We had all of those kinds of conversations. So where the electronic will, the Uniform Act ended up was to say that the electronic will can be valid with electronic testator signature, electronic witness's signature, but we decided to have the add-on piece of it in terms of extra protections be to make it self-proving. So in the uniform version of the statute, and there are lots of in the statute, if you look at the uniform version, not the version we've drafted, I don't think the brackets are still there, but in the uniform version, there are brackets all over the place because there are options for states, because we know that this will be a hard conversation in the states. The way it works in the uniform version is that the document is valid if it's signed by the testator and signed by the two witnesses electronically, but it's not self-proving unless one of two circumstances. If everybody is in the same room, the testator and the two witnesses are all in the same room, but for some reason they don't have a printer, so they're all signing the document electronically, then it can be self-proving using a notary who is also in the same room and who is not authorized for remote notarization. If any one of those people is outside the room, and we use presence, and it's not a room, but presence as understood under state law. If anyone is outside the room, one of the witnesses, the notary, whatever, then the will can be made self-proving only if remote online notarization is used, because that provides a significant additional level of protection. And one of the things I learned in the course of this project was how much protection remote online notarization provides, because there is a protocol for confirming identity that happens. But in addition, when that process is completed, the document is locked in a way that later tampering is going to be evident, at least under current technology. Things always change, and I recognize that. But it's actually, I think, going to be easier to tamper with a paper will than it will be with a will that has been notarized using remote online notarization, which is why I've been very pleased to see that Oregon's going to be considering that bill. I think that's going to be really important as we think about electronic wills, because it will provide a lot of protection. The notary who's authorized to do that then keeps a video recording of the whole execution ceremony. And it's a pretty cool, we had the process presented to us, and it's a pretty cool process. So I haven't used up quite all the time. I have a couple more minutes, but I wanted to give you an overview. Oh, and I'll say one thing about the article that I sent you CLE materials from a professor named Jerry Beyer, who, and I think the CLE materials are really good. They're very accessible. He makes a couple of the points that I made. This is inevitable. It's coming whether we want it or not. And his second point is, it doesn't appear, to the extent that we have information, that fraud is going to be any more of a problem with this than with paper wills, because it's certainly possible with the paper will to have someone apply undue influence to someone and get a will signed doing that. I sent you his materials. I also have a law review article that I've written that's a lot more in the weeds, talks about the 4 states and what they've done and how they're different. Be happy to send that to anybody who's interested in that. After a couple of different titles, I settled on the title for that article that is Facing the Inevitable, because that's what it really is. A lot of us who are estate planning lawyers who've been doing this for a long time don't like it, but it's coming, whether we want it or not. That's what we got.
Great. Any questions for Susan? We will have plenty of time for further conversation about this. Thanks, Susan.
Susan, it's just Heather Gilmore. I was just going to say, I posted in the comments that I hate this, but I'm not stupid and I don't want to put my head in the sand. It's already legal to do a revocable living trust with electronic signature in Oregon. You can do everything for the trust except the deeds and any other assignment document that requires a notary. So you just have your pour over will that's not electronic. And at least now, but not for long, you don't have your funding documents. So I don't know, I'm not a fan of this at all, but I'm not opposed to getting out in front of it so we don't end up with some other legislation that's horrible.
Thanks, Heather. And that was part of the push for the drafting committee. And actually it was a pretty quick process by uniform law standards, was the idea of getting out in front and having something that we had a lot of input. We had input from the industry, but we had a lot of input from elder law lawyers and estate planning lawyers and other folks who were interested to try to come up with a good, well thought out document that, if we're gonna be stuck with this, we want something that that has been created thoughtfully.
Susan, was ACTEC, I assume ACTEC was well represented on the drafting committee?
Oh, yeah. Yeah.
How about state courts? Did they have an observer?
I don't know that whether they had an official observer or not. I don't remember.
Okay, I'm just curious.
Yeah.
Anybody from the National College of Probate Judges?
Gosh, I think so, but I'm trying to remember if there was somebody officially or not. Maybe not. I'm not sure.
All right, well, we are out of time for today. We won't vote on this this morning.
Oh, shucks.
Yeah. So, next time I'll work with Susan and Sandy. Maybe next time we might go back. Well, first of all, we'll finish up, and I hope it's only just polishing the remote attestation witnessing draft that we've been working on. And then let's dive back into Chapter 111 and maybe reserve some further time generally about conversation. I think before we get into any kind of consideration of the specifics of e-wills, it'd be worth having the kind of conversation. I think Heather, your conversation or your comments were dead on. That I think all of us are going to be really queasy about the subject at all. But is it just a matter of the brave new world that is coming to us, and is it better to get out in front of it than to be run over by it? That's the kind of conversation I think would be worth having before we get into the specifics of the draft itself. So we'll try and carve some time out for that as well, not specific to the draft, but the conversation generally about our receptivity to it. And Sandy, I guess we'll probably send out a doodle poll.
Yeah.
Okay.
It seems like we're on this 2-week calendar. It seems to make sense. I'll send out a couple dates based off that time frame. Lorianne, if you could send me an updated copy of from the discussion today. And then I'm also going to send out when I get the draft from Lorianne, also the updated version of 111. I'll send out this probably early next week as well for you to review ahead of the meeting.
Thanks, everybody. Good meeting. A lot of progress.
Hold on,
Lorianne.
Actually, Sandy, I think you and I'll just give you a call to talk about the Chapter 111.
Oh, that's right. Okay. Sounds good.
Okay.
All right. Whatever. Okay. Thanks, everybody. Stay healthy. Meeting adjourned.